I was standing in my backyard in Scottsdale, Arizona, staring at a freshly dug trench that cut straight through my property line when I realized something was very, very wrong. My name is Patrick Sullivan, and I had just bought this house 6 months ago. It was my dream home, a beautiful ranch-style property with 3 acres of desert landscape, complete with saguaro cacti and mountain views. The HOA seemed reasonable during the buying process, just your typical suburban governance with standard rules about fence heights and lawn maintenance. I should have known better. The trench was about 4 feet deep and ran from the street, across my front yard, through my side property, and into the neighboring development. Inside it, I could see thick PVC pipes and electrical conduit, heavy-duty stuff. This was not some minor landscaping project. I pulled out my phone and called the number on the work permit sign that was staked near the street. A gruff voice answered after 3 rings. "Yeah, Desert Utilities Management. Hi, I'm Patrick Sullivan. You have construction happening on my property at 4582 Saguaro Ridge Drive." I never authorized any work here. There was a pause. "Hold on, let me check the paperwork." I heard papers shuffling. "Says here we have authorization from the Saguaro Hills Homeowners Association. Work order signed by Linda Ferguson, HOA president." My jaw clenched. The HOA doesn't own my property. They can't authorize work on land they don't own. "Sir, you need to take that up with the HOA. We just do the work we're contracted for. If there is a problem with authorization, that is between you and them." I hung up and immediately searched for Linda Ferguson's contact information in my HOA documents. I found her email and phone number, then called her directly. It rang 6 times before going to voicemail. "This is Linda Ferguson, Saguaro Hills HOA president. Please leave a detailed message, and I will return your call within 3 business days. 3 business days. I was looking at construction equipment actively tearing up my property, and she wanted 3 business days. I left a terse message explaining the situation and demanding an immediate callback, then walked over to the construction crew. There were 4 workers, all focused on laying pipe into the trench. The foreman, a weathered man in his 50s with a sunburned face, looked up as I approached. "Excuse me, I need you to stop work immediately. This is my property and I never authorized this construction." He wiped sweat from his forehead. "Look, buddy, I understand you are upset, but we have a valid work order. If you have an issue, you need to resolve it with whoever hired us. We cannot just stop mid-project. You are trespassing on private property without permission. I am telling you right now to stop." The foreman sighed and pulled out his phone. He made a quick call, spoke in low tones I could not quite hear, then turned back to me. "My supervisor says we continue working unless we get official documentation that the work order is invalid. Do you have documentation? I own this property. That should be documentation enough." "Sorry, man, not how it works. Get me something in writing from the HOA or a court order and we will stop. Otherwise, we have a job to finish." I felt heat rising in my face that had nothing to do with the Arizona sun. I went back inside and started making calls. First, I tried Linda Ferguson again. Voicemail. Then I called the HOA management company listed on my documents. After navigating through an automated system for 10 minutes, I finally reached a human. "Saguaro Hills Management. This is Trevor speaking." I explained the entire situation, trying to keep my voice level. Trevor listened patiently, then spoke in that infuriatingly calm customer service voice. "Mr. Sullivan, I show here that the utility installation project was approved at the February HOA board meeting. It is part of a development expansion to connect the new Saguaro Hills Phase 3 homes to the existing infrastructure. Nobody asked my permission to run utilities through my property. Well, sir, according to our records, the project was announced in the January newsletter and discussed at the open board meeting. All homeowners were invited to attend and voice any concerns. I never received a January newsletter, and I was not aware of any meeting. The newsletter was emailed to all residents. Let me check your email on file. He paused. I show newsletter at psullivan2025@gmail.com. That is not my email address. My email is p.sullivan@gmail.com. No 2025. Another pause. Oh, I see the discrepancy. That must have been a data entry error when you purchased the home. I apologize for that confusion. An email typo doesn't give the HOA the right to run utilities through my land without permission. There needs to be an easement agreement for something like this. Mr. Sullivan, I am just the management company representative. Legal matters need to be directed to the HOA board. I can pass along your concerns to Linda Ferguson. I have already tried reaching Linda. She is not answering. She is very busy, sir. The HOA board members are all volunteers with full-time jobs. I am sure she will get back to you as soon as possible. I hung up and immediately Googled real estate attorneys in Scottsdale. I found a firm called Morrison and Associates that specialized in property rights and HOA disputes. Their next available consultation was in 4 days, but they agreed to squeeze me in for an emergency phone consultation that afternoon. At 3 o'clock, I spoke with Daniel Morrison, a partner at the firm. I explained everything while watching through my window as the construction crew continued destroying my yard. Patrick, this is a clear case of trespass and potentially illegal installation of utilities without proper easement rights, Daniel said, his voice confident and reassuring. Arizona law is very specific about this. An HOA cannot simply decide to use private property for common infrastructure without either an existing easement or negotiating a new one with compensation to the property owner. So what do I do? They are actively working out there right now. First, send a certified letter to the HOA board and the construction company demanding immediate cessation of work. I can draft that for you today. Second, document everything. Take photos, videos, measurements. Third, if they don't stop work within 24 hours of receiving the cease and desist letter, we file for an emergency restraining order. How much is this going to cost me? Initial consultation and letter, $500. If we need to file in court, we are looking at a $3,000 retainer to start. However, if we win, which I am very confident we will, the HOA will likely be required to pay your legal fees along with damages. I did not have much choice. Let us do it. Daniel emailed me a client agreement and the cease and desist letter within 2 hours. I printed multiple copies and hand-delivered them to the construction foreman, then overnighted certified copies to Linda Ferguson, the HOA management company, and Desert Utilities Management. The next morning, the construction crew was back at 7 in the morning. The loud beeping of machinery woke me up. I threw on clothes and ran outside. "Did you receive the cease and desist letter?" I shouted over the noise. The foreman shrugged. "Got it. My company's legal department says to keep working until we hear otherwise from them. Like I said yesterday, this is between you and whoever hired us." I called Daniel Morrison immediately. "They are ignoring the cease and desist." "Okay, we are filing for the emergency restraining order today. Can you get to the courthouse by 10? I made it to the Maricopa County Superior Court with 15 minutes to spare. Daniel met me outside, a tall man in his 50s with steel gray hair and a no-nonsense demeanor. We went through security and headed to the appropriate filing office. The process took 3 hours. We had to fill out forms, provide evidence including photos and videos I had taken, present the cease and desist letter and proof of delivery, and explain the situation to a court clerk, who then passed it to a judge for emergency review. At 2 in the afternoon, we finally got our hearing before Judge Raymond Chen. The courtroom was small, just a standard hearing room. Daniel presented our case efficiently, showing the judge the property deed, the photos of construction, and the lack of any easement documentation. The HOA had been notified of the emergency hearing, but no one showed up to represent them. Judge Chen reviewed the documents for about 10 minutes, then looked up. "Mr. Sullivan, I am granting a temporary restraining order. All construction on your property must cease immediately until this matter can be properly heard. We will schedule a full hearing within 2 weeks. The court will send the order to all parties involved." Relief flooded through me. Daniel and I walked out together, and he handed me copies of the court order. "Deliver one to the construction crew right now. They stop work immediately or they are in contempt of court." I drove straight home. The construction crew was packing up for the day when I arrived. I handed the foreman the court order. He read it, sighed heavily, and nodded. "Okay, this we have to follow. We will pull out tomorrow morning." He looked genuinely sympathetic. "For what it is worth, I am sorry about the mess. We just do what we are told." "I understand. It is not your fault." That evening, my phone finally rang with a number I recognized from the HOA documents. "Mr. Sullivan, this is Linda Ferguson." Her voice was sharp, irritated. "I received notice about your restraining order against our utility project." "Linda, you ran utilities through my property without permission. What did you expect, Mr. Sullivan? Perhaps if you attended HOA meetings like you are supposed to, you would have been aware of this project. We announced it properly and followed all procedures." "You sent the announcement to the wrong email address. And even if you had not, announcing something doesn't give you the right to use my private property without an easement. The HOA has the authority to make improvements for the benefit of the community. This is outlined in the CC and articles you agreed to when you purchased your home." I had already reviewed the covenants, conditions, and restrictions with Daniel. The CC and articles give you authority over common areas and to enforce architectural standards. They absolutely do not give you the right to install utilities through private property without an easement agreement. Mr. Sullivan, you are being very difficult about this. The new development needs these utilities, and your property happens to be the most direct route. We are not asking for anything unreasonable. Then you need to negotiate an easement with me and provide fair compensation. That is how property rights work in America, Linda." She made an exasperated sound. "This is exactly why HOAs exist, Mr. Sullivan. To prevent individual homeowners from obstructing projects that benefit the entire community. We will see you in court." She hung up before I could respond. The next 2 weeks were relatively quiet. The construction equipment was removed from my property, leaving behind a partially filled trench and a torn-up yard. I documented all the damage with photos and added it to Daniel's file. The HOA, meanwhile, sent me 3 violation notices. The first claimed my mailbox was the wrong shade of beige. The second said my garbage cans were visible from the street. The third stated that my yard was not properly maintained, citing the massive trench their own construction project had created. Each violation came with a $50 fine. I forwarded all of them to Daniel, who literally laughed when he called me back. "They are retaliating. This actually helps our case. Save every single piece of documentation they send you." The full hearing was scheduled for a Wednesday morning. Daniel and I arrived at the courthouse at 8:30. This time, The HOA had representation. A woman in her late 40s with short blonde hair styled in what I could only describe as the classic "speak to the manager" cut sat at the defendant's table with a lawyer, a thin man in an expensive suit who looked thoroughly bored. Linda Ferguson wore a pink blazer and too much perfume. I could smell it from across the room. She glared at me as I sat down. Judge Chen entered and we all stood. Once everyone was seated, he reviewed the case file and looked up. "This is a hearing regarding the temporary restraining order filed by Patrick Sullivan against Saguaro Hills Home Owners Association regarding unauthorized utility installation. Counselors, please present your arguments." The HOA's attorney, who introduced himself as Richard Wainwright, spoke first. "Your Honor, the Saguaro Hills HOA is a properly established legal entity with authority granted through the CC and RTCS that govern the community. The utility installation project was properly announced and approved through the HOA's standard procedures. Mr. Sullivan's objection appears to be based on a personal grudge rather than legitimate legal grounds." Daniel stood. "Your Honor, personal feelings are irrelevant. The legal issue is simple. The HOA does not have an easement to run utilities through Mr. Sullivan's property. Without an easement, they are trespassing and installing permanent infrastructure without legal authority. The CC and RTCS, which I have here, make no provision for the HOA to claim easement rights over private property for utility installation." Judge Chen held out his hand and Daniel passed him a copy of the CC and RTCS, with relevant sections highlighted. The judge read for several minutes. "Mr. Wainwright, do you have documentation showing an existing easement for utilities across Mr. Sullivan's property?" Wainwright shuffled papers. "Your Honor, we are arguing that the HOA's authority to make community improvements includes the reasonable use of property within the community for infrastructure purposes." "That is not what I asked. Do you have an easement, yes or no?" "No, Your Honor, but we believe the CC and RTCS provide implicit authority." "Implicit authority is not the same as an easement right, Counselor. Easements must be explicit and recorded." "Do you have any precedent showing that HOA covenants can override property rights without explicit easement language?" Wainwright looked uncomfortable. "Your Honor, we would argue that the announcement process and board approval constitutes sufficient authorization under the HOA's governing authority." Judge Chen removed his glasses and rubbed his eyes. "Counselor, that is not how property law works. An HOA cannot simply vote to take easement rights over private property. If the HOA needs access to Mr. Sullivan's land for utilities, they need to negotiate an easement agreement with him or pursue eminent domain through the proper legal channels, if they even have that authority, which I doubt." Linda Ferguson suddenly stood up. "Your Honor, if I may." Judge Chen looked surprised but nodded. "Madam, you are welcome to speak, but please be aware that you have legal representation and should probably confer with your attorney first." "I understand, Your Honor, but I think there has been a misunderstanding. Mr. Sullivan is making this sound much more complicated than it is. We are a community. The new development benefits everyone, including Mr. Sullivan. His property values will go up. We were just trying to be efficient by using the most direct route for the utilities. If we had known he was going to be so unreasonable about it, we could have discussed compensation, but he immediately went to lawyers and courts instead of working with us." Daniel stood again. "Your Honor, Mr. Sullivan attempted to contact Mrs. Ferguson multiple times before retaining legal counsel. She did not return his calls. The HOA management company dismissed his concerns. The construction company ignored his verbal requests to stop work, and continued even after receiving a cease and desist letter. Mr. Sullivan was forced to seek legal protection because no one would acknowledge his property rights. Judge Chen nodded slowly. Mrs. Ferguson, the issue here is not about being reasonable or unreasonable. Your HOA installed utilities on private property without permission. That is trespassing and potentially criminal property damage. The fact that you think it benefits the community does not override Mr. Sullivan's legal rights as a property owner. Linda's face turned red. But we announced it properly. Everyone had a chance to object at the meeting. Did Mr. Sullivan receive notice of the meeting? Wainwright quickly intervened. Your Honor, there was an administrative error with Mr. Sullivan's email address, but the notice was posted in the community newsletter and on the HOA website. So Mr. Sullivan, through no fault of his own, did not receive direct notice. Even if he had, attendance at an HOA meeting is voluntary. Failure to attend does not constitute consent to use of private property. Here is my ruling. Judge Chen picked up his gavel. The temporary restraining order is made permanent. Sagaro Hills Home Owners Association is permanently enjoined from conducting any construction or installation on Patrick Sullivan's property without a properly executed and recorded easement agreement. Furthermore, the HOA is ordered to restore Mr. Sullivan's property to its original condition, including professional landscaping to repair all damage caused by the unauthorized construction. This work must be completed within 30 days. Linda looked like she wanted to argue, but Wainwright put a hand on her arm and shook his head. Additionally, Judge Chen continued, Mr. Sullivan is awarded costs and attorney fees associated with this action. The HOA will submit to Mr. Sullivan's counsel an itemized payment within 14 days. If the parties wish to negotiate an easement agreement going forward, that is between them, but it must be voluntary on Mr. Sullivan's part with fair market compensation. This hearing is concluded. The gavel came down and relief washed over me. Daniel shook my hand, grinning. That went even better than I expected. As we walked out, Linda Ferguson intercepted us in the hallway. Up close, she looked even more furious. I hope you are happy, Mr. Sullivan. Your selfishness is going to cost the entire community hundreds of thousands of dollars to reroute those utilities. My selfishness. Linda, you dug up my property without asking. How is protecting my legal rights selfish? Because you are putting yourself ahead of 300 other families who need those utilities for their homes. Daniel stepped between us. Mrs. Ferguson, I strongly suggest you do not harass my client. The judge ruled in our favor. Accept it and move on. She turned her glare on him. This is not over. We will be sending Mr. Sullivan a bill for our legal costs and the rerouting expenses. The HOA bylaws allow us to assess individual homeowners for costs they create. You can try, Daniel said calmly, but I promise that will not end well for the HOA. My client did not create these costs. Your decision to trespass created them. Any attempt to assess him will result in another lawsuit, which you will lose. Linda made a disgusted sound and stormed off, her heels clicking aggressively on the marble floor. Over the next month, the HOA did comply with the court order, though clearly under duress. A landscaping company came out and filled in the trench, replaced damaged irrigation lines, and replanted desert vegetation that matched my existing landscaping. The work was professional and thorough. I received a check for $8,300 covering my attorney fees and court costs. I also received another violation notice, this time claiming my house numbers were faded and needed repainting. I took high-resolution photos of my house numbers, which were clearly in perfect condition, and forwarded the notice to Daniel with a note. "They really cannot help themselves, can they?" he replied. "Document everything. We are building a harassment case if we need it." The harassment continued. Over the next 3 months, I received 14 violation notices for increasingly absurd infractions. My front door wreath was supposedly not in compliance with architectural guidelines, even though identical wreaths hung on 6 other doors on my street. My garden hose was visible from the sidewalk. My car was parked improperly in my own driveway, though the notice never specified what was improper about it. Each notice came with a $50 to $100 fine. I did not pay any of the fines. Instead, Daniel and I filed a motion with the court documenting the pattern of retaliation. Judge Chen reviewed the evidence and issued another order, this time finding the HOA in contempt of court for retaliating against me for exercising my legal rights. All fines were voided, and the HOA was ordered to cease issuing any further violations to my property, unless they could demonstrate a legitimate, documented violation with photographic evidence and citation of the specific rule violated. The violation stopped after that. I thought the matter was finished, until I received a certified letter from the HOA 4 months after the court hearing. Inside was a special assessment bill for $47,000. The letter explained that the utility rerouting project had cost significantly more than anticipated due to complications created by an uncooperative homeowner. The HOA board had voted to split the excess costs among all homeowners in Phase 2 of the development, which included my home. My portion was $47,000, due within 30 days. I was so angry I had to put the letter down and walk away before I could think straight. When I finally calmed down enough, I scanned it and emailed it to Daniel. He called me within an hour. "Patrick, this is beyond retaliation. This is potentially fraud. They are trying to financially punish you for asserting your legal rights. We are going back to court, but I think we also need to involve the Arizona Attorney General's office. This kind of abuse of HOA authority is exactly what their real estate division investigates." Will that actually help? It might. At minimum, it puts pressure on the HOA board. They are operating like they are above the law. A formal investigation will make them realize they are not. Daniel filed 2 actions. First, another emergency motion asking Judge Chen to void the special assessment. Second, he submitted a formal complaint to the Arizona Attorney General's Real Estate Division outlining the HOA's actions. The unauthorized utility installation, the retaliatory violations, and the punitive special assessment. The emergency hearing was scheduled quickly. This time, when we arrived at court, the HOA had a different attorney. Richard Wainwright was gone, replaced by an older woman named Patricia Brennan who looked far more competent and far less bored. Linda Ferguson was not present. Instead, the HOA had sent their vice president, a nervous-looking man in his 30s named Marcus Chen, no relation to the judge. Judge Chen did not look happy as he reviewed the case file. "Mr. Sullivan, it appears you are back in my courtroom regarding the same HOA. Counsel, please explain this special assessment." Patricia Brennan stood. "Your Honor, the special assessment is a standard mechanism allowed under Arizona HOA law to distribute unexpected costs among homeowners. The utility rerouting was necessary because the original route became unavailable, and the costs must be borne by someone. The HOA board determined that spreading the costs among Phase 2 homeowners was the most equitable solution. Counselor, according to the documents filed by Mr. Sullivan's attorney, he is the only Phase 2 homeowner being assessed the full excess cost. Is that accurate?" Patricia looked surprised and turned to Marcus Chen, who whispered something to her. She turned back to the judge. Your Honor, I apologize. I was not aware of that detail. I will need to review the board minutes. Judge Chen's expression darkened. You came to court without reviewing the board minutes about the very assessment we are here to discuss. Let me save you time. According to the evidence submitted, Mr. Sullivan is the only homeowner receiving this special assessment. No other Phase 2 residents are being charged. This is not cost distribution. This is targeted financial retaliation. Marcus Chen suddenly stood up. Your Honor, I think there has been a terrible misunderstanding. I am the HOA Vice President, and I was not present at the meeting where this assessment was voted on. Looking at these documents now, I can see this does not look appropriate. I would like to request a continuance so the board can reconsider. Denied, Judge Chen said flatly. The HOA has had ample opportunity to act appropriately. Instead, there appears to be a pattern of harassment and retaliation against Mr. Sullivan. The special assessment is void. Furthermore, I am issuing an order that the Sagaro Hills HOA Board must attend mandatory training on HOA law and property rights. The board is also prohibited from issuing any assessments, fines, or violations to Mr. Sullivan's property without first having them reviewed by an independent attorney, not affiliated with the HOA, who will certify in writing that the action is legally justified. He looked directly at Marcus. Mr. Chen, I suggest you go back to your board and inform them that continued abuse of authority will result in more severe consequences, including potential personal liability for board members. Do you understand? Marcus nodded vigorously. Yes, Your Honor, I will make sure they understand. After the hearing, Marcus approached me hesitantly. Mr. Sullivan, I want to apologize. I honestly had no idea Linda was doing all this. Most of the board did not know either. She was acting unilaterally on a lot of these decisions. Where is Linda now? She resigned from the board yesterday. Once word got out about the Attorney General's investigation, several homeowners demanded her removal. She quit before we could vote her out. He ran a hand through his hair. Look, I know this has been awful for you. The whole situation was handled terribly. I would like to make it right if possible. Would you be willing to discuss an easement agreement, with proper compensation, of course? I glanced at Daniel, who gave a small nod. I am willing to discuss it, I told Marcus, but it needs to be fair and it needs to be done properly. Absolutely. I will have our attorney, a new attorney, reach out to set up a meeting. Again, I am really sorry about all of this. Over the next 6 weeks, we negotiated an easement agreement. The HOA agreed to pay me $35,000 for a permanent utility easement across a clearly defined strip of my property, along with an additional $10,000 for the inconvenience and disruption. They also agreed to maintain the area, including any landscaping, in perpetuity at their expense. Daniel reviewed the agreement and confirmed it was fair. I signed it, the payment cleared, and the utilities were finally installed properly. I thought that was truly the end of it, until I received a call from an investigator with the Arizona Attorney General's office named Sarah Martinez. Mr. Sullivan, I am following up on the complaint filed regarding Sagaro Hills HOA. I wanted to let you know that our investigation has uncovered some additional issues beyond what you experienced. What kind of issues? I cannot share all the details as it is an ongoing investigation, but we have discovered evidence that the former HOA president, Linda Ferguson, may have been embezzling funds from the HOA accounts. The utility project appears to have been partly a scheme to hide budget discrepancies. I sat down heavily. You are saying she was stealing money? That is what the evidence suggests. We found approximately $80,000 in unauthorized transfers from HOA accounts to personal accounts controlled by Mrs. Ferguson. She was using fraudulent expenses and assessments to cover the missing funds. Your situation helped us uncover the broader pattern. I wanted to thank you for filing the complaint. If you had not, this might have gone undetected for years. What happens now? We are referring the case to the Maricopa County Attorney's Office for criminal prosecution. Mrs. Ferguson will likely face charges of theft, fraud, and embezzlement. I cannot promise specific outcomes, but these are serious charges. After we hung up, I just sat in my living room staring out at my repaired yard. The whole situation had been so much worse than I realized. What started as the HOA running utilities through my property without permission had uncovered systematic corruption and theft. 3 months later, I received a call from Daniel. "Patrick, I thought you would want to know. Linda Ferguson was arrested this morning. She is being charged with 14 counts including embezzlement, fraud, and abuse of fiduciary duty. The county attorney's office is taking it seriously." "Good," I said simply. "There is more. Several other homeowners in the development have come forward with their own complaints about Linda's behavior. Turns out you were not the only one she retaliated against. The new HOA board is actually cooperating fully with the investigation and has offered to make amends with everyone affected. They are doing complete financial audits and implementing new oversight procedures. The criminal case took another 8 months to wind through the system. Linda Ferguson initially pleaded not guilty, but the evidence against her was overwhelming. Bank records, forged documents, testimony from other board members who had questioned her actions and been pushed out. Eventually, her attorney negotiated a plea agreement. She pleaded guilty to multiple felony counts and was sentenced to 4 years in state prison, along with restitution payments to the HOA of $80,000 plus interest. She also faced civil lawsuits from multiple homeowners, including one from me for damages related to the harassment and illegal assessment attempts. The new HOA board, led by Marcus Chen as president, turned out to be competent and reasonable. They sent a formal apology letter to me and several other homeowners who had been targeted by Linda. They implemented new policies requiring board votes for all major decisions, mandatory financial audits by independent accountants, and a homeowner bill of rights that explicitly outlined property owner protections. My civil lawsuit against Linda Ferguson was settled out of court. Her homeowner's insurance, which covered some acts by board members, paid out $25,000 in damages. I used half of it to install a beautiful water feature in my front yard, right near where the illegal utility trench had been dug. Every time I looked at it, I remembered that standing up for your rights, even when it is difficult and expensive, matters. The utility easement money went into my savings account, a nice cushion for the future. The settlement money felt like validation that I had been right to fight back. One afternoon, about a year after the whole ordeal started, I was working in my garage when Marcus Chen knocked on my open garage door. "Hey Patrick, hope I am not interrupting." "Not at all. What is up?" "I wanted to give you this." He handed me a bottle of wine. "It is from the entire HOA board. We just finished our first full year of operation under the new procedures, and everything is running smoothly. A lot of homeowners have told us they feel better about the HOA now, more transparent and trustworthy. You played a big part in making that happen, even though I know you would have preferred not to." I took the wine. "Thanks, Marcus. I appreciate that. Also, I wanted you to know that we are working with a developer to create alternative utility routes for any future expansion. We have purchased easements from willing sellers and are establishing proper procedures. What happened with your property will never happen to anyone else in this community." After he left, I opened the wine and poured myself a glass. I sat on my back patio, looking out at the desert landscape and the mountains in the distance. The Arizona sunset painted everything in shades of orange and purple. My phone buzzed with a text from Daniel Morrison. "Saw the news about Ferguson's sentencing. Congratulations on seeing it through. You did good." I smiled and texted back, "Thanks for everything. Could not have done it without you." Another text came in, this time from my sister Emily, who lived in Oregon. She had followed the whole saga with a mixture of horror and fascination. "Just read the article about your HOA president going to prison. That is insane. Are you finally done with all the drama?" "Finally done," I texted back. "Everything is back to normal. Well, normal with a better HOA board and $45,000 in settlement money. You should come visit. Get away from Arizona for a while. Maybe next month. I am actually starting to like it here again now that I am not fighting with the HOA constantly." That night, I made dinner and ate on my patio, enjoying the quiet. The whole experience had been exhausting, frustrating, and expensive despite winning attorney fees back. But it had also been necessary. If I had not fought back, Linda Ferguson would have continued abusing her power, embezzling money, and running roughshod over homeowners' rights. Sometimes standing up to bullies, even when they have official titles and organizational authority, is the only way to stop them. The legal system, despite its slowness and expense, had ultimately worked. Judge Chen had seen through the HOA's arguments and protected property rights. The Attorney General's investigation had uncovered the deeper corruption. The criminal justice system had held Linda Ferguson accountable. I thought about all the homeowners in communities across America who deal with abusive HOAs. Many probably do not fight back because it seems too hard, too expensive, too risky. They just pay the fines, accept the violations, and hope to stay under the radar. I understood that impulse. I had almost done the same thing multiple times during my case, but property rights matter. The rule of law matters. Holding people in power accountable matters. If homeowners do not stand up for their rights, HOAs will continue to expand their power beyond legal boundaries. A few weeks later, I attended my first HOA meeting since the whole situation began. I had avoided them during the legal battle, but Marcus had personally invited me, and I was curious to see how things had changed. The meeting was held in the community clubhouse, a nice facility with a pool and meeting rooms. About 40 homeowners attended, a much larger turnout than typical according to Marcus. The meeting was professional and transparent. Marcus presented financial reports, which were also available in printed form for anyone who wanted them. The board discussed upcoming projects and asked for homeowner input. They voted on new landscaping for the common areas and debated the pros and cons of different contractors. It was, in short, exactly what an HOA meeting should be. During the open comment period at the end, an older woman named Dorothy raised her hand. "I just want to thank the new board for how you have handled things this past year. After everything that happened, a lot of us were thinking about selling and moving away. But you have restored our faith in the community." Several people applauded. Marcus looked genuinely pleased. "Thank you, Dorothy. We are trying our best, and I want to acknowledge Patrick Sullivan, who is here tonight for the first time. Patrick, your willingness to stand up to the previous board's overreach ultimately helped all of us. It exposed problems that needed to be fixed, so thank you." More applause. I felt my face flush with embarrassment but nodded in acknowledgement. After the meeting, Several neighbors came up to introduce themselves. Many shared their own stories of problems with Linda Ferguson, violations that seemed arbitrary, fines that felt punitive. One couple, the Hendersons, told me Linda had tried to fine them $500 because their palm tree was not the approved variety, even though the tree had been there for 15 years before Linda became HOA president. "We paid it because we did not know we could fight back," Mrs. Henderson said. "When we heard about your case, we realized we should have stood up to her too." "It is not too late," I told her. "If you have documentation, you might be able to recover those fines through the restitution process." Their eyes lit up. "Really? How do we do that?" I gave them Daniel Morrison's contact information. "Tell him I referred you. He will know how to help." Driving home that night, I realized something important. My case had not just been about protecting my own property. It had been about protecting the entire community from abuse of power. By fighting back, I had made things better for everyone, even people I had never met. The HOA had installed utilities through my property without easement rights, violated my property rights, harassed me with frivolous violations, attempted to financially ruin me with an illegal assessment, and all of it turned out to be connected to embezzlement and corruption. It had been a nightmare, but nightmares end. Mine ended with justice served, property rights protected, and a community made stronger through accountability. I pulled into my driveway and sat for a moment, looking at my house. This was my home. I had fought for it, protected it, and ensured that no one could arbitrarily take my property rights away. That meant something. Inside, I poured another glass of the wine Marcus had brought and raised it in a silent toast. To property rights, to standing up for yourself, to the rule of law, to communities that work the way they are supposed to, with transparency and respect for individual rights. My phone buzzed one more time. Another text from Daniel. "By the way, the Hendersons just contacted me. Thanks for the referral. Looks like we will be recovering some more of Ferguson's illegal fines. You are building quite the legacy there." I smiled and texted back. "Just trying to make sure everyone knows their rights. Someone has to." That someone does not always have to be you, Patrick. You have done your part. Enjoy your wine and your fountain and your peace and quiet. He was right. I had done my part. The investigation was over. The criminal case was resolved. The HOA was reformed. My property was repaired and properly compensated with a legitimate easement. The harassment had stopped. It was finally, actually, truly over. I took my wine out to the patio one more time and watched the stars emerge in the Arizona sky. The desert night was cool and peaceful. Somewhere in the distance, a coyote howled. My fountain gurgled pleasantly. This was what I had bought when I purchased this house. Peace, space, privacy, and the security of knowing my property rights would be respected. I had almost lost it to HOA overreach and corruption, but the legal system, despite its flaws, had protected those rights. I thought about Linda Ferguson, probably sitting in a cell in the Arizona State Prison, wondering how her life had gone so wrong. Part of me felt bad for her. She had destroyed her own life through greed and abuse of power. The consequences were entirely self-inflicted. But mostly, I felt grateful that she had been stopped before causing even more damage. How many other HOAs had presidents or board members who acted the same way? How many got away with it because homeowners did not know their rights or did not have the resources to fight back? These were bigger questions than I could answer. All I could do was share my story, encourage other homeowners to stand up for their rights, and hope that my experience helped someone else avoid similar problems. The next morning, I woke up early and went for a run through the neighborhood. The sun was just rising, painting the desert in golden light. I ran past the new Phase 3 development, where houses were being built. The utilities that the HOA had tried to run through my property had eventually been installed using properly purchased easements from other willing homeowners. The development was thriving. I ran past the community park, where kids were already playing on the playground equipment. I ran past neat rows of houses with well-maintained yards and tasteful desert landscaping. It was a nice community. It had survived its brush with corruption and come out stronger. When I got back home, sweaty and tired, I found a letter in my mailbox. It was from the Arizona Attorney General's office. I opened it, half expecting more legal complications. Instead, it was a thank you letter. Sarah Martinez had written to tell me that the investigation I had helped trigger had led to reforms in HOA oversight laws. The state legislature had passed new requirements for HOA financial transparency and homeowner protections. My case had been cited in the legislative testimony. Sometimes one person standing up for their rights creates ripples that extend far beyond their individual situation, Sarah wrote. Thank you for being willing to fight back. You have made a real difference. I stood in my driveway holding the letter, feeling a strange mix of emotions. Pride that my case had led to broader reforms. Frustration that it had been necessary in the first place. Relief that it was finally over. Satisfaction that justice had been served. I went inside and pinned the letter to my refrigerator, right next to a photo of my completed fountain and a copy of the easement agreement. Reminders of a battle fought and won. The rest of my day was gloriously ordinary. I worked from my home office, handling my normal job responsibilities as a software engineer. I had lunch on my patio. I did some yard work in the afternoon, trimming plants and adjusting my irrigation system. I grilled dinner and watched a movie. It was peaceful, normal, and exactly what I wanted my life to be. As I was getting ready for bed, my phone rang one last time. It was Marcus Chen. Patrick, sorry to call so late. I wanted to give you a heads up. A reporter from the Arizona Republic called me today. They are doing a story on HOA reform and the Ferguson case. They want to interview you. I gave them your number but told them to ask you first before using your name. I hope that is okay. Yeah, that is fine. Thanks for the warning. No problem, and Patrick, thank you again for everything. I know I have said it before, but it bears repeating. You saved this community. After we hung up, I thought about whether I wanted to talk to a reporter. Part of me wanted to just move on and forget the whole thing. But another part of me recognized the opportunity to help other homeowners who might be dealing with similar situations. When the reporter called the next day, I agreed to an interview. We talked for over an hour. I told the whole story. Finding the construction on my property, the HOA's refusal to acknowledge my rights, the legal battle, the retaliation, the discovery of embezzlement, the criminal prosecution, and the eventual reforms. The article was published 2 weeks later under the headline, How One Homeowner's Fight Against HOA Overreach Exposed Corruption and Led to Statewide Reforms. It was thorough and fair, presenting the facts without sensationalism. My phone number was not published, but my name was included. I received dozens of emails from other homeowners sharing their own HOA horror stories and asking for advice. I responded to as many as I could, always with the same message. Document everything, know your rights, do not be afraid to fight back when the HOA oversteps, and find a good lawyer who specializes in property rights. Several people told me they had used my story as inspiration to challenge their own HOAs. Some had success, others were still fighting. All of them thanked me for speaking out. A month after the article was published, I received an invitation to speak at a homeowner rights conference in Phoenix. The organizers wanted me to share my experience and discuss property rights and HOA accountability. I initially declined, uncomfortable with public speaking. But then, I thought about all those emails from homeowners who felt powerless against their HOAs. I thought about the reforms that had come from my case. I thought about the difference one person can make by refusing to back down. I accepted the invitation. The conference was held on a Saturday in downtown Phoenix. There were about 200 attendees, mostly homeowners, but also some lawyers, legislators, and HOA board members who wanted to learn how to run their organizations properly. I was nervous as I walked to the podium, but once I started talking, the words flowed naturally. I told my story from beginning to end. I explained the legal principles involved. I emphasized the importance of documentation and knowing your rights. I talked about the broader implications and the need for HOA oversight and accountability. When I finished, the applause was genuine and sustained. During the question and answer session, people asked thoughtful questions about easements, property rights, legal strategies, and how to identify HOA corruption. One woman raised her hand. "Mr. Sullivan, how much did all of this cost you in terms of time and stress? Was it worth it?" I thought carefully before answering. It cost me months of stress, probably years off my life from the anxiety, and even though I recovered my attorney fees, there were still out-of-pocket costs. Was it worth it? Absolutely. Because property rights matter. Because holding people accountable matters. Because standing up to bullies matters. If I had not fought back, Linda Ferguson would still be embezzling money and abusing homeowners. Sometimes the right thing to do is also the hard thing to do. After my presentation, several people came up to shake my hand and share their stories. A legislator told me he was working on additional HOA reform bills and asked if I would be willing to testify before a committee. I said yes. Driving home that afternoon, I felt a sense of closure I had not expected. The nightmare that started with finding construction equipment in my yard had transformed into something meaningful. My suffering had not been pointless. It had led to accountability, reform, and inspiration for others facing similar battles. That is what I hold on to now, 2 years after the whole ordeal began. My property is peaceful. The utilities run through a properly established easement for which I was fairly compensated. The HOA is well run and transparent. Linda Ferguson is in prison, serving her sentence and paying restitution. Reforms have been enacted to protect homeowners across Arizona. And every time I sit on my patio and listen to my fountain, I am reminded that standing up for your rights, even when it is difficult, even when the opponent seems powerful, even when the system seems rigged against you, is always worth it. Because in America, property rights still matter. The rule of law still matters. And one person who refuses to back down can change everything. My name is Patrick Sullivan, and I found the HOA installed utilities through my property without any easement rights. I fought back and I won. Not just for myself, but for everyone who believes that property rights and the rule of law should mean something. That is my story, and I hope it helps someone else who is facing their own battle against HOA overreach. Document everything. Know your rights. Find a good lawyer. And never, ever give up when you are in the right. Justice may be slow, but it is real, and it is worth fighting for.